Big news for Indians planning to study, work, or settle in the US. The US government has now announced a strict new immigration rule that could create serious problems if visa or green card forms are signed incorrectly. Yes, TimesXP has covered it earlier, but this time with a new update. The US Department of Homeland Security, also what we call as DHS, said that from July 10, 2026, the immigration forms will be invalid if signatured with a digital sign. In some cases, applicants may also lose their filing fees as well. Till now, if a form was unsigned or had a signature mistake, the US Citizenship and Immigration Services, the USCIS, usually sent the form back to the applicant so that it could be corrected. But this time, under the new rule, the mistake is discovered later during the check, even months or years after submission. USCIS officers can directly deny your application. This is especially important for Indian students, IT professionals, and families applying for the US visa, because India is one of the largest groups using the American immigration system for last decade mostly. USCIS says that only certain types of signatures will now be accepted. These include a proper handwritten signature, a handwritten X, a thumbprint, or an official electronic signal submitted through USCIS online system. Now, even a scanned copy of original handwritten signatures are still allowed. What are not allowed? Let me tell you. The USCIS has warned that several methods are not acceptable anymore. These include the typing your name instead of signing, using a stamp, copy-pasting a signature image, or using a signature-making software. Now, lawyers, agents, and interpreters also cannot sign for the applicant unless officially allowed. Now, the rule applies to many common immigration categories. What are these categories? Well, these categories include H-1B visa, F1 student work-related visa, OPT, STEM OPT forms, green card applications, work permits, citizenship applications, employer-sponsored petitions, and so more. For Indian viewers, experts say that this means that applicants must be extra careful while filing the forms. Even a small signature mistake could delay the dream of studying and working in America. Immigration lawyers say that advising people to double-check every single page before submission and then keep a proper record of the signed documents. With that, USCIS has also clarified that there is usually no guarantee of chance to get inside US once application is done. But application is never properly filed in the first place, then the chances shrink. Now, this is a new rule that is something you cannot afford to ignore. The US Department of Homeland Security, DHS, has clarified the new USCIS signature rule is starting that if the immigration authority discovers the immigration form has an invalid signature, it may now either reject or deny the application. That in some cases also filing fees is also rejected. Now, USCIS under the United States Citizenship and Immigration Services usually reject the forms. But under this updated rule, if the issue is discovered months or years during the adjusting period of USCIS, officers can deny your visa instead of simply sending it back. The rule applies to only a benefit request submitted to USCIS or after July 10, 2026. DHS is amending its regulations governing the submission of benefit request and provide that if the US Citizenship and Immigration Services accept a benefit request that determines later that it lacks a valid signature, USCIS may in the discretion reject or deny the request. If it does not meet the regulatory requirements to ensure the better enforcement of the signature requirements, it reads a notice filed in US Federal Register on 11th May 2026. This interim final rule is effective on July 10, 2026. USCIS says that it counts a valid signature, and USCIS said valid signature are handwritten signatures, the X a thumbprint with the proper electronic signature submitted through official USCIS filing only. Scanned or photocopied versions of an original handwritten signature are still not allowed. Poll: do you think applicants should have a chance to correct invalid signatures after submission? Yes, they should be allowed. Not the current rule is fine, but there are more amendments to it. What USCIS says is not allowed, while USCIS specifically warns against it. The typewritten names instead of the signatures, stamp signatures, the copy-pasted signatures, image signatures created using a signature software that someone else is signing it without the proper authority. Now, attorneys prepare or interpreters signing it applicants is also not allowed. What does USCIS new rule signatures law apply to the new USCIS signature rule is very broad, and it can affect almost all of the immigration benefit applicants who file the forms with USCIS, and not just with visa category. That means the following group could be affected with their form that contains invalid signature: employment-based visa applicants, the family-based green card applicants, H-1B visa, L1, F1, student visa-related USCIS filings, OPT, STEM, and all of them status applicants form related to 485, the work permit applicants, AD asylum applicant files, U visa applicants, naturalizations, citizenship, and what all. Basically, all of the categories that are under the US visa filings should have a proper valid visa. Now, the rule specifically mentions forms such as Form I-918, which is the U visa petition, as an example where delays could become a major issue if a signature problem discovered later. What are your thoughts on this? Make sure to comment down below.